Judiciary of Cambodia. The judiciary of Cambodia is independent from the rest of the government of Cambodia, as is specified by the Cambodian Constitution. The judiciary follows civil law tradition, the instruction being entrusted to a judge and the prosecutors contenting themselves with requesting the application of the law. Courts and tribunals in Cambodia regularly face a lack of resources, both financial and human. A ferment of corruption and clientelism that eat away at the whole of society. The difficulty of access for the poorest also favors the resistance of traditional methods of conflict resolution based on the intermediary of a person whose moral authority, unlike that of the judge, is not contested by neither of the two parties, village, districts, pagoda chiefs, etc. de facto, creating a two-tier system, one official reserved for foreigners and urban elites, and the other informal for the most part population. History of judiciary of Cambodia. Before the establishment of the Khmer Empire, it seems like the civilization of Funan had a rudimentary judiciary with probably a legal code of Indian origin. Trial by ordeal existed and innocence could be decided if a suspect was not eaten after being thrown to the ubiquitous crocodiles. Khmer Empire, an extended judiciary network. In Khmer inscriptions of the 10th and 11th century, there are indications of well-established judiciary in the Anglo-Korean Empire. From the text, it can be interpreted that the king was personally involved, but given the location of these inscriptions, it is likely that the court were delegated to act on behalf of the ruler. According to Alien Lustig, sites with mentions of the royal service, courts and court officials are distributed in much the same way as non-royal inscriptions, suggesting relatively even administration of taxation and law. The first written traces of law are Dharmashastra that appeared during the Indianization of the Indo-Chinese peninsula between the 2nd and the 13th century. But these texts are above all codes of conduct, respectful of secular customs and devoid of directive character. Moreover, when at the end of the 19th century, French people such as Adhémard Leclerc did research on the laws of the Anglo-Korean period, they realized that they are the most part unknown to magistrates. In fact, corruption with the nepotism practices and clientelism attached to it made the law particularly inaudible. Justice under the French protectorate of Cambodia. The first attempt of codification. French colonization aimed to transform Cambodia to guide the Khmer people towards the idea of progress as defined by the French protectorate. The protectorate saw the first real attempts at codification, but these codes were often in contradiction with the laws enacted in metropolis or those which applied to the whole of French Indochina. The opinions, orders, and other decrees issued by the various legislative bodies were streamlined on 1st of June 1940 by creating a hierarchy between them. At the highest level was now the Krem, which derived from the sole monarch and had a general legislative scope. The Court was also the work of the king, but covered the appointments, transfers, and dismissals of senior officials. The Samrak related to a decision taken by the Council of Ministers. The practice came for the part from any minister and applied to his field of activity, while the Decca had only a local value: province, districts, commune. Injustice under the Khmer's Rouges. Codification continued after the independence, led by Cambodian lawyers trained at the Faculty of Law, where courses were partly given by French professors in French. Under the regime of a democratic Kampuchea, the judiciary had power only in name. Closely linked to politics, the National Committee for Justice officially came into force at the end of the single session of the Assembly of the Representative of the People of Kampuchea, April 11 to April 13, 1976, which, according to Article 9 of the Constitution, also had the task of appointing magistrates at all levels of the hierarchy. The ministry was chaired by Kangchep, elected according to the rule of democratic centralism. Justice was to be rendered by the people's courts, which were supposed to defend the democratic rights and freedoms of the people, and which actually condemned any action directed against the state. Unlike the Soviet Union or the Socialist Republic of Vietnam, democratic Kampuchea stood out from other communist states on the planet by the absence of its judicial system. No tribunal nor court of any sort was ever invested with the power to render justice. Most of the players in the old judicial bodies did not survive this period, and the restoration of institutions is still in progress. With the fall of democratic Kampuchea in 1979, popular revolutionary courts were finally created, but it was not until 1982 that a more elaborate judicial system was put in place. A network of provincial courts was born, dependent on a popular Supreme Court at the national level, which became the instance of appeal. A decree law of July 13, 1982 completed the whole by creating a hierarchy of the level of the text of laws. The laws or chabab emanated from the Council of State under the Presidency of Republic and had to be approved by the National Assembly to be proclaimed, or if its application could not wait for the next parliamentary session, by decree law. The latter did not need a promulgation and takes effect as soon as it is signed. In return, it is repealed if it goes against a chabab. The decree or enunciate, for its part, would come from the Council of Ministers, but could not oppose one of the two texts mentioned above. Each minister or head of a public body could, at this level, enact an order or practice, while the revolutionary committees can issue decisions or such a day, Samarak, in compliance with any of the acts mentioned above. Monarchy restored. In 1992, the United Nations Transitional Authority in Cambodia added to the provincial jurisdictions already created an appellate court, which was also invested with the power to review the judgments of the military tribunal, and whole decisions could be challenged before a Supreme Court. This reform was also accompanied by a recognition of the text, but in view of the text to be accomplished, it was preferable to sort among those of the previous regimes, those which would be repealed and those to be retained. The 1993 Constitution restored parliamentary monarchy, retained the order of the legal text adopted by the People's Republic of Kampuchea. However, the royal crown, which had been repealed in 1970, now reappeared with the limited power of promulgation of the laws voted by the parliament. At the same time, the law was profoundly overhauled by international aid. Many bodies responsible for organizing and guaranteeing the independence of institutions were then created: Superior Council of the Judiciary, Bar of Lawyers, Council of the Orders, etc. But this implementation, by calling into question the previously established system of influence, regularly lead to crises such as the quarrel between Kai Tak and Suon Bichel, which disrupted the functioning of the bar for several years, or the accusations of partially of the Superior Council of the Judiciary after the transfer in March 2004 of Judge Hing Tirith. The establishment in 2006 of the extraordinary chambers in the courts of Cambodia, a local jurisdiction with minority international participation responsible for judging the last leaders of the Khmer's roots, helped to accelerate the establishment of institutions closer to international standards. Surya Subedi, then rapporteur for the United Nations Commissioner for Human Rights, noted in his report of August 2014 that progress could still be made. In fact, the assessment made in 2006 by Anthony Fontaine, project manager of the Embassy of France for legal cooperation with the Royal University of Law and Economics of Phnom Penh, showing that the path that leads to the rule of law is still a long term, and Cambodia is barely beginning to borrow it. Is still relevant years later. A structure of judiciary of Cambodia. The main duties of the judiciary are to prosecute criminals, settle lawsuits, and most importantly, protect the freedoms and rights of Cambodian citizens. However, in reality, the judicial branch in Cambodia is highly corrupt and often serves as a tool of the executive branch to silence civil society and its leaders. Until 1997, Cambodia did not have a judicial branch of government, despite the nation's constitution requiring one. Hierarchy of courts. The judicial power entrusted in the first instance to the provincial courts and then to the Court of Cassation and the Supreme Court. It is based on a single jurisdictional order, and each of these bodies rules on cases that fall under both civil law and criminal law, commercial law or social law. Provincial courts are municipal courts of cities with special status, such as Phnom Penh or Sihanoukvale, are composed of a judge, a prosecutor, and a clerk. The Court of Appeal, Shala Hotel, the Court of Appeal sits in the capital. In the mid-2010s, two more instances opened in Battambang and Siem Reap. In addition to appeals against provincial court cases, it also judges administrative disputes at first instance. In addition to the institution in charge of this type of case, the court has 4 other chambers specializing respectively in civil, criminal, commercial, and investigation. Its decisions are rendered by a group of 3 magistrates. The attributions of the public ministry fall to the public prosecutor at the Court of Appeal. The Supreme Court of Cambodia, Tolakar Kampol, rules as a last resort on cases tried on appeal, but can only rule on defects in legal procedure. It is composed of a civil chamber and a criminal chamber. Decisions are pronounced collegially by 5 magistrates or 9 magistrates in a plenary judgment, while the functions of the public ministry fall to the public prosecutor at the Supreme Court. Finally, the Supreme Court of the judiciary holds judicial power in the last instance. It is supposed to guarantee the independence of the judiciary and intervenes in matters relating to the promotions, transfers, and remuneration of judges. It must also deal with complaints and decide, if necessary, on disciplinary sanctions against magistrates. Its organization and functioning have been redefined by a law promulgated in July 2014, which notably increased the proportion of the judges sitting on the Supreme Court. The highest court of judicial branch is the Supreme Court of the Magistracy. There are currently 17 justices on the Supreme Council. Administrative acts. In Cambodia, the administrative acts are organized according to a hierarchy inherited from the People's Republic of Cambodia. At its top is the Kret, a decree signed by the king and countersigned by the prime minister and the minister concerned. It is in fact the act of promulgation of Chebab voted by parliament. Anukret is a sub-decree passed by the government and initiated by the prime minister and the minister responsible for its application. The practices are taken by a minister or the governor of the central bank, while the decisions of Sanctity Samraj is initiated by a member of the government, including the Secretary of State or the President of the public institution. An interior order called Circular or Soracho is prescribed by a central administration for its local officers. Its purpose is to clarify a legal text by indicating the interpretations to be given to it or to define a policy in a given area. Finally, the DECA has a more limited scope and is the work of a provincial governor or head of municipality. People in the judiciary of Cambodia. Prosecutors. The Public Prosecutor's Office is the only body authorized to prosecute but cannot judge cases. Prosecutors are subordinate to the Attorney General, who receives his instructions from the Ministry of Justice and must send him an activity report every year. In order to put an end to the confusion which then prevailed, the Supreme Court of the Judiciary decided on July 11, 2005, the administrative separation between the judges in charge of investigating cases and those conducting the trials. Judges of Cambodia. In 2003, Judge Kim Sathavi was in charge of establishing the first Royal School for Judges and prosecutors to train a new generation of magistrates and legal clerks for Cambodia. Since then, judges and prosecutors are recruited by a competition open to any law graduate, and after having undergraduate training at the Royal School of Magistracy. Lawyers of Cambodia. The lawyers are grouped in an order governed by the Crème of 22 and inspired by its French counterpart. At its head is a General Assembly, a council of the order and bâtonnier elected for a 2-year term, renewable once applicant to the profession must be of Cambodian nationality, have obtained a certificate of aptitude for the career of lawyer and a law degree or an equivalent diploma and not have been convicted of a criminal offense. They must then complete a 1-year internship in a firm and include additional training. Finally, to ensure their independence, lawyers are required not to exercise a commercial activity or a job in the public service in Southeast Asia or in any political or jurisdictional institutions in Cambodia. Thank you, viewers.